Hi, good evening, everyone. Thanks for tuning in tonight. We are excited to have everyone join us for our first virtual town hall. Thanks for hanging in there with us. We are going to start to get started. My name is Megan Reckling, and I am a candidate for state representative in the 47th district. That is a large portion of Livingston County that goes all the way from Heartland and Tyrone Township, all the way across the top of Livingston County over to Cohocton, and then down to the southwestern portion of our county, all the way down in Unadilla Township, and also covers the city of Howell. I have almost 20 years of legislative experience. I have worked in both the Michigan House and the Michigan Senate, helping different members on a large number of public policy issues, from teacher tenure to state employee healthcare reforms. And so I look forward to the opportunity to having you get to know me, why I want to be your next state representative. And I look forward to our topic tonight, which is discussing we're going to discuss a couple of different lawsuits related to COVID-19. Mitch is working on getting our presentation up right now so we can get going, and he'll introduce himself in just a minute. But as we have been campaigning, I know that as I have been campaigning and I've been talking to different voters and neighbors of mine who live throughout Livingston County, talking to them about the concerns they have with what's going on right now, a large number of people start to ask me about the different lawsuits that have been filed against our governor. There's really never been an occasion where our governor has been sued as many times as she has been in the past couple of weeks here. And a lot of people don't understand what the process is to sue our governor or our government, what that looks like, why there are lawsuits being filed in both federal court and in state court, in the Court of Claims. They don't understand how the process works, what the lawsuits look like, and really the governor's authority overall related to the number of different emergency management laws that we have here in our state. So Mitch and I teamed up. He's an attorney that has some experience with the lawsuits going on with the governor, and he has been helping some businesses related to the executive order. And so since I only play a lawyer on TV, and I am not one, I am honored to have him with us here tonight to really give a good legal overview of some of the different lawsuits that have been filed, walk people through the process, what it looks like, and then answer questions that any of you guys might have. So we welcome everybody who has registered and is joining us on Zoom, and then we welcome everybody else who is tuning in on Facebook Live. So I am going to turn it over to Mitch. Hopefully he can multitask and talk at the same time.
I think so. All right. It's great to be here with everyone. Very much excited about this opportunity to talk a little bit about the law and how it intermixes with some of the issues that we have in local government. Really excited to be here with Megan. And as she mentioned, I am an attorney, and many of you probably know me as I'm a candidate also for the County Commission, District 6, which handles Marion, Putnam, and Hamburg Townships. As Megan said, we're looking hopefully to give you a 30,000-foot view in terms of our presentation of all these different lawsuits, and then also be able to answer some questions. We can get as deep in the weeds as the questions may take us, and then certainly we can take discussion offline if that needs to happen as well. My experience is in not just the law, but also formerly an engineer. I have a mechanical engineering degree, used to work at Fiat Chrysler, and so I bring with me a lot of different background of experience in terms of large corporation, working with small business, working in the law, and then also I'm a football coach in town. So I like to think that I can cross all bridges and help interpret on all different topics with a variety of different audiences. So I think we're all set. Everyone should be able to see our screen here and kick it off from there. What's going to happen is we're going to talk a little bit about these 6 different cases, 5 really, and then the 6th topic with some additional other cases, so to speak. The plan will be that we focus on kind of a progression from state court all the way into the federal court and what the differences are. And Megan's going to spend some time with us talking about, based on all of her experience in the House and the Senate, talking about that lawsuit. And then we'll answer some questions at the end. So this first case, this is the Shocky versus Whitmer case. Many of you may recognize this as the lawsuit that had to do with the number of petitions and the timing to file petitions for the congressional candidates and the Michigan Court of Appeals candidates. This case was filed in the Eastern District of Michigan, and what that means is it was filed in federal court on the eastern side of the state. And so the main federal court building is down in Detroit, but there's a handful across the east side. And actually, Judge Berg, who handled this case, he is down in Detroit, and I've been in front of him several times. What he did was he issued an overall extension of the deadline, which many attendees probably are familiar with, but also decided to cut the number of required petitions in half. So that was the basis for what actually led forward into a Court of Appeals case. The Judge Berg said, these are not normal times. And I think all of us on the webinar can agree with that. And he also said that the reality on the ground is, from a constitutional basis, the rug got ripped out from underneath these candidates, and their ability to collect signatures was significantly impaired, or severely harmed is the legal jargon that is used to cover this motion for a preliminary injunction as the parties brought forward. So as I mentioned, the case was appealed. It went to the Sixth Circuit Court of Appeals, which is the court that oversees Michigan, Ohio, Kentucky, Tennessee, with respect to appeals matters. And the judges it's a 3-panel judge setup, and the judges said that the federal courts don't have the authority to tell the states exactly how they should handle conduct with respect to the elections. But the court did say that the state can remain required to select an adjustment process or an adjustment method, whatever process they choose, to reduce the burden on the access to the ballots and to narrow the restrictions in order to protect the interests of the candidates that are filing in this case. So essentially, the court said, fix it. We just can't tell you how to specifically fix it. Ultimately, there were no changes made by the state, and this was actually contemplated by the Sixth Circuit. They said one of the solutions the state could decide to do is follow through with what Judge Berg said. That could be a solution. We're not telling them that it is or that it isn't. And ultimately, we saw that the state didn't modify how it was treating this election. So that's one of the early cases that got us kicked off in this series of COVID-19 lawsuits. The next one was another case, also probably familiar with many folks that are attending today, but it's the case that was brought forth in the Court of Claims, and the judge ultimately denied the plaintiff's motion for preliminary injunction. Preliminary injunction is basically, think of a cease and desist that gets issued, and the judge says, you have to stop doing this, or you must do this. It's the way that the courts are able to control the actions of a different party. So the plaintiffs were seeking this injunction against the governor, against the attorney general, asking the court to tell them to stop with the executive orders, and ultimately the judge denied that. The plaintiff said that it's an infringement on constitutional rights. It's getting in the way of our due process. It's also, they weren't treating the Michigan state law and constitution rules. They weren't following those rules accordingly. And the governor, the attorney general, the defendants said, well, first of all, there's no jurisdiction here. They said that the Court of Claims wasn't the proper position for this lawsuit. They also said that we're going to issue some new executive orders here shortly. So it's what's called moot. These issues don't matter anymore. We're going to solve them ourselves. And lastly, they said, notwithstanding, this is all within our police power, so this is all within the state's power to make decisions in light of emergencies such as this to control and keep the population safe. The court said, sorry, this is the right jurisdiction, and there's many issues that are ripe for our review, such as the stay-home order itself, the travel ban, access to public land, and the constitutionality in general of the Emergency Management Act. And so the case proceeded. The court said that both issues of the constitutional differences between the parties, so the substance of the motion, which says you can't move, you can't go here, you can't do these things, as well as the process, or what we call the procedural due process, the way at which the decision was reached. The judge said, in either case, this is a question of balancing that needs to happen. We need to balance the rights of the parties with the state's interest to protect public health. And the judges in this case laid out a very straightforward analysis that said, ultimately, these individual constitutional rights are not absolute. They're subject to balancing, and we have to balance those against the state's interest, what they claim is an interest to protect the health and safety of the population in Michigan. But the judge was very clear, and he said, we can't for a second pretend that issues like exigent circumstances, the health and safety issues that pop up, we can't pretend that they become more important than the constitutional rights that we're given. We can't say that those rights become less, the constitutional rights become less important, or they become unenforceable for some reason. And we can't ignore the rights outright in the name of public interest. However, the court said that there are cold rules of law, and that quote comes right from the opinion. He said we have to follow these cold rules of law in order to do the balancing test that we were just discussing. So with respect to the cold rules of the law and the balancing question that's necessary, the question is, does the executive order have a real or substantial relationship to the public health crisis that is not beyond all question, plain, palpable invasion of rights? So what that means in layman's terms is there some sort of relationship to what the governor is saying she's trying to do in the executive order and the health crisis that exists in the state of Michigan? The way that the judge reached their determination is they said at the time that these executive orders were issued, there was an undisputed amount of facts that said there is some sort of disease that's going around. And so the stay-home order was made in response to the existence of this disease that was going around. And because it was made in response to that, there at least is a relationship between the public health crisis and the rules that were issued. Finally, the court determined that even though this may not be the case in every new virus, even though there may be sicknesses that come about in some future time that don't warrant such a drastic action, the court has to conclude that in general, issuing the injunctive relief does not serve the public interest despite the temporary harm to the plaintiff's constitutional rights. So the judge decided ultimately he wasn't going to deal with the constitutional aspects of the implications of making such a determination of whether to stop the EO from continuing or to allow it to continue. Ultimately, he said, my job is to balance whether or not there's a relationship between the EO and this health crisis. I've determined that there is, and we'll let some of the other courts figure out the constitutional aspects.
So up next is one of the lawsuits that I know I personally have been asked quite a bit about, probably because I was a staffer in both the House and the Senate for a while. And that is the lawsuit that last Wednesday was filed jointly by the Michigan House and the Michigan Senate. So that case is basically where the legislature asserted that the actions of the governor through the number of executive orders, I think we're well over 70, 75 executive orders now, are not authorized, well, the newer ones, are not authorized by statute, and that they violate the separation of powers. So this case is before the State Court of Claims. That court was created back in 2014. The legislature created that court, and it is a specialty court in Lansing where all of the lawsuits, if you're going to sue the state or someone acting in capacity of the state, like the Attorney General, the Secretary of State, the governor, that's where you would file the lawsuit, is in the Court of Claims. And so a lot of people have been talking about the two different laws of which the governor has been using her executive authority to make and issue the orders that she has. The first one is the 1976 Emergency Management Act. This says that the governor can declare a state of emergency for up to 28 days. And then after 28 days, it requires legislative approval for any extension thereafter. The legislature did grant an initial extension on her authority, and then recently they refused to grant her the most recent extension, which is where we're at. So the the legislature is basically asking, are all of the executive orders issued after the court authorized under the current statute? The legislature in their claim said, court, the governor's contrary interpretation of the Emergency Management Act would nullify the EMA's careful subscribed cooperative regime, produce absurd results, and render the legislature's role basically nullify it. It would also defeat a central purpose of the statute, and it would allocate powers across both the legislative and executive branches to respond to the crisis. So basically what the legislature is saying is if the governor's interpretation stands, which she has a couple of them, they would be rendered ineffective for as long as the governor deemed there was an emergency. The governor is trying to claim that every 28 days she can reissue a state of emergency, and therefore one will end when she decides that it ends. The next act that the governor has been citing frequently is related to the 1945 emergency powers of the Governor's Act. The legislature says that in the plain text, it reveals that the act was intended to address more civil disturbances in selected areas of the state. That act actually starts off with language that refers to in times of great public crisis, disasters, rioting, catastrophes, or similar public emergencies within the state. And so the legislature is making the argument that that language was specifically created back in the 40s related to the Detroit riots. And therefore, the interpretation and the legislative intent behind that is that it be used for assisting locals to respond to emergencies in small areas of the state, not throughout the state. The legislature is also saying that if the acts are to coexist, which a lot of people believe that they do, regarding public health emergencies, that they are in peri materia, which it means on the same subject matter. And therefore, in other legal terms, if you do, that means the 28-day restriction should also apply to the emergency powers of the Governor's Act. The last thing is the legislature has argued that since they have acted, that the emergency response is over and the legislature should be able to work within the accordance of their constitutional duties going forward. So what that means is that in the very beginning, there are some constitutional rules that take the legislature a little bit longer to react. So there's something called the 5-day rule, which means when a bill passes between chambers in the House and the Senate, it is required to sit in the opposite chamber for 5 days. So when the House passes a bill and then it's the Senate's turn to vote on it, that bill is required to lay over for 5 days. That is a constitutional requirement. There is no suspending of the rules or anything that either the House or the Senate can do to make that process go any faster. So 5 days is the fastest that bills can move between the House, the Senate, and end up on the governor's desk for signature. So basically what the legislature is saying is we understand that the original act was created with the intent that sometimes things run a little slower through the legislature, and they recognize that they might need to act a little fast. However, the legislature has started to do their job again. They have started to pass bills. They have started to pass bills that basically codify the governor's existing executive orders, some of them. And so they have acknowledged that they are back doing their job. They're able to do their job in the time that it takes to respond, especially related to re-engaging, and that they should now be able to do so. So that case, again, is before the Court of Claims, and they have scheduled oral arguments on that case for Friday morning at 10 o'clock. We will post the link to those later on in the comments and on our Facebook pages, where you can watch the oral arguments if you want. Again, it is a joint lawsuit between the House and the Senate, so they combined in the same lawsuit. And we look forward to seeing how that turns out in the Court of Claims. So I'll turn it back to Mitch to discuss some other lawsuits, and then we'll move on from there.
Thanks, Megan. Great job. There's a really important kind of transition that happens in this case, as you know, from the cadence of the cases that we're talking about. The first two cases we talked about are already settled. So there's already been opinions, at least preliminary opinions, that have come forward. In the case of the Sixth Circuit Court of Appeals has decided the issue, and also the time for filing is already passed. So that is handled in all respects, or most respects. The Court of Claims case that was decided with denial of the preliminary injunction, there's already, again, been an order issued on that. This Michigan House and Senate versus Whitmer case is pending. As Megan said, it is not decided, and you can see that there are key issues of Michigan state law that are being addressed. And in the preliminary, or the earlier cases, or the previous case in the Court of Claims anyways, there was a discussion, again, of state law and the application of state law. What we're looking at now is really a transition into federal court. So we talked briefly about what federal court is in that first case of the first case, where we were talking about whether or not the federal court can control how a state runs its elections. Really is a question of state law, and that's why the court said, I'm going to kick it back to the states to come up with their plan. In these next two cases, this is the Signature et al. Case, which has 7 plaintiffs, business plaintiffs across the state that have raised what are called federal questions. So these are questions that only federal courts can address. And they've been filed instead of the Eastern District of Michigan, they've been filed in the Western District of Michigan on the basis that Lansing is in the Western District, and that would be then the proper venue or location to file these lawsuits based on the state of Michigan's locality. So my hope is we don't dive too deep into, you know, what the dormant commerce clause is, and privilege and immunities, and how these all play into a big philosophical impacts, but really want to highlight the basis for the lawsuit that's been brought by these 7 plaintiffs. With respect to the dormant commerce clause, basically what the plaintiffs are saying is the governor has given an impermissible restriction on our right to engage in interstate commerce. And interstate commerce is simply transactions over state lines. So there's a real estate company that is a plaintiff in this case, and they're arguing that because of the governor's order, it's not possible for them to engage in out-of-state folks who want to buy houses or rent real estate here in Michigan. So anything that crosses state lines is a dormant commerce clause issue. The privileges and immunities clause, there's 2 different claims in this lawsuit, and what a privilege and immunity claim stands for is just as it sounds. There are privileges and immunities that residents of one state have that should be carried over into other states. And so travel from state to state, engaging in commerce, as we've already discussed from the dormant commerce clause perspective, these are privileges and immunities to all U.S. citizens, and the plaintiffs in this case say that because of the orders, those privileges and immunities are being infringed upon. Procedural due process, we kind of mentioned it earlier, but it basically talks about the way in which a government decides the restrictions that are being set forth with respect to the liberty of the individuals. So in this case, the liberty in terms of the right to contract, the liberty in the way in which the parties engage in their occupations of normal life, and just generally the way that they engage in privileges that are part of their normal pursuit of happiness or orderly pursuit of happiness by free men. So the way at which the decision of the government came to make these restrictions is what is at issue for that claim. Then the substantive due process issue is actually the act itself is, quote, shocking the conscience. So it's so absurd, or it's so far beyond the bounds of what would be practical to be able to be allowed as a restriction on activities from a citizen, or it interferes with the rights that are implicit in what we have come to know as ordinary liberty. The equal protection issue is one, if you were watching the press conference earlier with respect to the barber in Owasso, one of the discussions that he was having, or his attorney was having rather, was we're allowing some businesses to operate, but others are not, and the way at which we're deciding that is arbitrary. So an equal protection violation talks exactly about that. There has to be some sort of rational basis or some sort of reasonable relationship. So they have to be connected in some way the restriction and the reason why the restriction is being implemented. So the question that the plaintiffs in this case are raising are associated with why are my businesses being restricted from operation, even though they're similarly situated or they're the same types of operations that go on in, say, a Walmart or a Target or something like this that would otherwise be allowed underneath the executive order. Why are they allowed and why am I not? And then the last claim that they're making is what's called void for vagueness, rather. And so basically what it says is the order is so confusing, the ordinary person who reads this order wouldn't understand it. And they rely on the fact that there's frequently asked questions surpassing 125 on this issue. So if it was so clear, why do we need to answer 125 frequently asked questions? And then the last case, this is the Paul Mitchell versus, again, Governor Whitmer and Director Gordon with respect to, again, a set of federal questions, not as much from the business perspective in this case, but rather from an individual's perspective. And you'll notice some of the same claims that are being brought, a privilege and immunities claim, that due process claim, both in the way of how the decision was made and then the actual decisions that were made. They're infringing on the rights of the citizens under the 14th Amendment, and then also that equal protection clause violation. So the big difference is this guarantees clause, and what it says is, as a part of the Constitution, the United States themselves guarantee that each state will act in the form of a Republican government. So basically, each state will act as a representative republic. So in the implementation of different police powers or the way in which the governor or any other body institutes restrictions or the daily operations of what the government allows to occur in the states, there is no implementation of that police power that allows states to slide away, even temporarily, the lawsuit claims from this Republican form of government. And they say in this case that the executive orders do impermissibly keep the entire state on lockdown. It's doing so indefinitely, which has the effect of a self-government as opposed to a Republican government. Similarly, we talked about the privileges and immunities. We have a restriction both on the restriction of the operation under a Republican government. So Congressman Mitchell's ability to live in a Republican government in the state of Michigan, and then also his ability to access medical care. I believe the lawsuit talks about a knee issue and his inability to address that knee issue because it was not one of the essential medical procedures underneath the executive orders. We have the same similar procedural due process issue. Again, restriction on the travel, the decision in which or how we made the decision, the governor made the decision rather, with respect to what kind of travel was allowed. In this case, we add the ability to associate politically, the ability to participate in political speech. The lawsuit alleges that those were infringed upon. And then also the ability to exercise his property interest in a second property in Michigan. We have the substantive due process issue, again, interfering with the rights that are implicit in a normal liberty. And then also the void for vagueness issue. Again, if this is so clear, if this makes so much sense, why is it that we have 125 frequently asked questions to help people better understand the issues? So in total, we have 17 cases, and I know, Megan, you wanted to chat briefly about these two examples of the 17. One with respect to—
You can take the first one and I'll take the second one.
Perfect. So the first one being the Michigan United for Liberty case. The plaintiff in this case is seeking, again, another preliminary injunction to stop the governor from continuing to act and issue orders under the Emergency Management Act and the EPGA on the basis, again, that both are unconstitutional delegations of legislative power. So it's very similar to the case that the state legislature is bringing against the governor.
So the other lawsuit that was filed that I think is worth note and talking about just for a second out of the 17 that have been filed is the Word of Faith Christian Center Church and other plaintiffs in that case. I believe there were over a dozen of them that sued the governor, and that was also in federal court. And the suit was filed when the original executive order stay-at-home order was issued that limited the religious establishments from holding church service. There were a lot of issues where the executive order was being applied, where even pastors and one person couldn't go to a church venue to do something like set up a live stream for their parishioners to watch church at home. And so a group of pastors got together and they sued the governor over a violation of the right to assemble and the right to our religious freedoms. And so pretty quickly, the governor issued a new executive order, which changed the restrictions related to churches. And because she did so, they basically won the lawsuit by default. In layman's terms, because the governor decided to change the language of the executive order to allow churches to go ahead and meet. The governor has also recognized lawsuits that have been filed against her related in federal court to the right to assemble. There was an individual who sued the governor that he basically said that his right to assemble and protest were being restricted by the executive orders. And the governor quickly did an about face on that as well and clarified that under the First Amendment, your right to protest, your freedom to assemble are protected, and you can go ahead and do those. So I know, as we said before, there are currently a total of 17 cases. I know there are a number of cases more that are going to be filed against the governor in the next couple of days, and I assume there's going to be significantly more in the next week or so as we continue to go on and the businesses aren't able to open and other individuals get frustrated. If you are joining us on Zoom, you can use your chat or your question and answer button to ask us a question. If you are joining us on Facebook Live, please feel free to type a question in the box. We are more than happy to answer any questions that you have related to the lawsuits that have been filed, either the ones that we mentioned. If it's ones that we didn't mention, we can do our best to try to answer it. If not, we can always circle back with you. One of the things that I would like to take just a quick moment to address is the process. A lot of people have asked me, what does the process look like when the governor is sued? And so when the governor is sued in the Court of Claims, basically the judge will decide to schedule oral arguments, which they have done. Well, first the case is done, there's a blind draw. Mitch, am I right? There's 5 judges on the Court of Claims?
Yes, that's correct.
Okay. So there's 5 different judges that serve on the Court of Claims, and cases are assigned by a random draw using a computer. And so this case has been assigned to Judge Shaw, correct?
The legislature's case?
Yes.
I think that's correct. Yeah, give me 1 second to pull it up.
And so she got the case on a blind draw. She is a Granholm appointee from back when Jennifer Granholm was the governor of Michigan. And so she has, like I said, scheduled oral arguments on Friday at 10. If the legislature loses the lawsuit, then they would be able to appeal that decision to the Court of Claims. I'm trying to keep my personal opinions out, whether they're going to win or lose, but all of the experts expect that no matter who wins or loses this case, and I agree with them here, that the case will be appealed. Whether the governor loses or the legislature loses, they will appeal the case. That will then go to the Court of Appeals, the State Court of Appeals, and it's pretty much an agreement through all of the legal experts that whoever loses there, the legislature or the governor, will then appeal the case. And if that case, that decision by the Court of Claims is appealed, it goes to the Court of Appeals. And if that decision is also appealed, then it goes before the state Supreme Court. and they will have the final decision to make as to where the legislatures or any other decisions that go to the Court of Claims, they're the final decision makers. So we have a question, and we'll go ahead and address that, and then we'll potentially address any other questions or go on from there. So the first question is, in your opinion, do you feel she will be able to continue with emergency powers and leave the legislature helpless to do anything? So I'll go ahead and answer, and then Mitch, I'll let you take a turn.
Sure.
Is that good? Okay. So I personally do believe that the governor is going to continue to use the 1940s statute and the 1976 statute, so the 1945, to continue to issue emergency orders. I have watched all of her press conferences, and even as of this afternoon during her press conference, she was asked specifically about the barber in Owasso who has opened up, and her exact quote was, "These orders are law until the court decides they're not." And so I believe that if you listen to the governor's talking points, if you listen to her rhetoric, if you listen to her words, I will say words matter all the time. I have written bills for a living for 20 years. Words are really important. She is using language that indicates she continues or intends to continue to issue executive orders until the court stops her. Now, whether that be the legislature's lawsuit, the Paul Mitchell lawsuit, or one of the others, that is to be determined. But I do believe that until the court tells her she can't, that she will continue to do this. It could come down to a question of what is considered reasonable. The court is probably going to say that she has reasonable expectations to these authorities. What does reasonable look like? Someone in my position would argue that 3 months is unreasonable for her to govern by herself, but the judge may have a different opinion on that. Go ahead, Mitch.
Yeah, I think Megan makes. Yeah, I think you make all good points there, and I think one important aspects of all of these cases is that there's claims that COVID-19 will be back in fall, and how severe at what time is can be left for debate, perhaps during coffee chats or something like this. But ultimately, what happens in these cases will help set the precedent for how the reaction is allowed to occur in the fall as well. And so the judiciary, whether they are Democrat leaning or Republican leaning, I think that in any respect, they have an understanding in general that what they're doing is setting the precedent for the future. And so that is a very heavy weight that they have on them. And I think that with respect to making a determination of statutory interpretation, and with respect to the Emergency Management Act or the governor's authority under the Governor's Act, in any case, making that determination will be a very important step that they will take in the next couple of weeks, perhaps, that will then play into how all emergency management crises play out in the future. There's another question from Taryn again that says, doesn't she have to have a proof of crisis? I think this is one of the points that the legislature is pointing out. And I think Megan did a nice job highlighting the question at this point is not what should be done, but who should handle it. And with respect to the legislature's case, they say that we are past the point of the emergency, and now we're in a position, we've formed these task forces, we've enacted and proposed tens, if not almost near 100 bills that are going to deal with COVID-19, not only in the emergency sense, but also dealing with financial implications down the road. I know there's a lot of discussion in at least the Republican caucus right now about the budget and what the impacts on the budget will be. And so those are all important questions. And I think that's the basis of one of the bases rather of the legislature's suit is we've got it from here. You can stand down. Let us do what we do, which is make laws, and you operate on the other side of our kind of separations of powers boundaries.
I agree with Mitch. I think that is kind of an argument in a couple of the lawsuits. And I know that the proof of a crisis or the proof of the crosstab data that she's using to make her decisions has been a question that not only the legislature is asking through a lawsuit, but a lot of individuals and residents across the state, especially here in Livingston County, have been asking to see. The data related to the, I'm going to sidetrack a little bit on what proof the governor has for the decisions that she's making away from the lawsuits. So a lot of people are concerned, especially in Livingston County, about the decision the governor made to put Livingston County in with Oakland and Wayne and Genesee County and Macomb County related to the Michigan Economic Recovery zones. And so that was a reclassification of where Livingston had been for almost 2 decades, related to the emergency readiness zones when we were over with Ingham County, Shiawassee County, Hillsdale County, and a couple others like that. So I know that I sent a letter to the governor last week asking her to reconsider the designation, especially of Livingston County, that she made within those Michigan Economic Recovery zones. I know that a lot of people have asked, and I personally don't believe that the governor has provided the public with a lot of transparent information related to the data, the crosstab data that she's using to make decisions. The governor will show us a graph or a little bit of, you know, a good looking graph during her press conferences or on a PowerPoint. But I would argue that my 5-year-old can draw a graph. What's important is that the data that was used to make the graph is the data that we're looking for, and that's kind of called crosstab data. And so that's the information that a lot of people are looking for, is what is the information that the governor used to put the graph together? Because dependent on what information is being used, as most people know, you can make the numbers show whatever you want. So I think that's a good question, and I think that's one that we should all continue to ask.
And I'll just double down on that. I mean, if we go back to the process from a legal perspective, Megan, that's a great explanation of what the burden of proof may be as we go forward, especially in the federal cases. And I can imagine perhaps that some of the discovery, which is basically when the parties start to ask the other side what type of information they have, types of communications have gone on internally on either side, those kinds of things. I can imagine that data will be a specific ask in discovery. So I presume that the plaintiff, whether it be the 7 plaintiffs in the business-related case or if it's Congressman Mitchell, certainly they'll be asking for all kinds of information, demanding it, and the governor and the attorney general and the related parties will all have to turn it over as a part of the normal process for any kind of lawsuit.
So Taryn, I think that answers your question that you sent us, that can a judge order the disclosure of data? Yes, and I would hope that they do, because that data is really being used to drive the policy decisions that the governor is making. At least that's what she claims. And those decisions are having drastic impacts on not only our businesses and our family, but our state budget and our state economy. And so hopefully that the parties and the judge will ask to see the data, the crosstab data behind the graphs that the governor has. Related to the, go ahead.
I was gonna say, Mark, you've got several good questions here. I'll try and knock them off quickly. When will the governor's response be filed in the legislature's case? I would expect it's no later than Wednesday.
It was ordered to be done by Wednesday.
Yeah, and I presume it would likely be before that, but at latest date, I think it's 5 p.m. on Wednesday. Luckily for us, I don't believe the Court of Claims is doing electronic service still, so it's got to be during business hours. Then the next question you had, Mark, was, would it make sense to have the legislature ask the judge to certify the questions to the Supreme Court and save a lot of time and expense ruling on the legislature's case? Process doesn't typically work that way, especially if from a judicial resources question perspective. I know what you're asking is, won't it save more time? Perhaps not. Perhaps it would. I think that would be a speculation type of answer to try and foreshadow whether or not it would save time. And then the regional zones, I think I understand your question, and Megan, feel free and jump in. Can Livingston County become a sanctuary county? And I think if I'm interpreting your question right, you perhaps mean, can it be a county where folks operate freely underneath from a business perspective? I don't know that there's anything that would allow that to occur. There'd be some sort of designation could be made, I presume, but I don't believe that there's any kind of official process that would exempt the county any further, other than similar types of actions that you've seen where sheriffs have taken positions. Sheriff Murphy's taken a position, I know, but nothing that would shield it completely.
So I do want to add a little bit of something there, because I do believe that while, and that's a great question, one that I would love to get an actual legal opinion on, that could the county become a sanctuary county? However, what my underlying concern would be is that the governor issued a request to call up the Michigan National Guard. And that request was approved by the president. And a lot of people don't like to read those, but I have. And the very last line of the governor's request to call up the National Guard said, quote, basically to assist the police with enforcement of these orders that the governor is issuing. So we do have a number of sheriffs throughout Michigan. I know that the Livingston County Sheriff, the Shiawassee County Sheriff, and there are others have said that they are not going to enforce the orders that the governor has issued, especially recently, because they believe that after the legislature did not decide to issue an extension, that the legal standing of her orders becomes very questionable, and they worry about the health and safety. I know that I've talked to our sheriff here in Livingston County, and he worries about the health and safety of his men and the people that they are, and women, and the people that they are coming in contact with when trying to enforce the order. And so I would argue that even if Livingston County did become a sanctuary county, that under the approved authorization of the state National Guard, that the governor and the attorney general could utilize the National Guard to enforce the orders if they so deemed that was necessary. Yes, that is kind of like a military or a police state. Yes, that should be alarming. And I don't know how far the governor would be willing to go. I think watching the Owasso Barber case is going to be really indicative of how hard they are going to go after businesses that decide to operate with what they deem is outside the realm of the executive orders. So I hope that kind of helps answer that question there. We have another question that came in. That is, the decisions that have been rendered by the courts so far have been favorable to the governor. Is there any indication that these new lawsuits will yield a different result? So that is a great question. I know Mitch is an attorney. You are kind of bound to keep your opinion more out of it. I, not an attorney, get to play a little bit more fast and loose with what my opinion is. So I think there's a couple of things. I think one, federal court lawsuits are more friendly to the legislature or businesses versus state lawsuits. The Court of Claims is mainly a Democrat appointed court. The Court of Appeals is mainly a Democrat appointed court. And then currently the Republicans hold a one majority, we have one justice more than the Democrats on the state Supreme Court. However, multiple justices that serve under the Republican Party are known to side with the Democrats pretty frequently. So I don't know that that is a sure win for Republicans to take anything to the state Supreme Court. Mitch, you have practiced in federal court, so you have a little bit more knowledge about what would lie on the road ahead of us on the federal court. But I think if we are looking to the state court, I do know that the judge who drew the legislature's court case, she has ruled with the governor twice, specifically Governor Whitmer, and she has ruled with the Republican legislature once. So she does have a history of, on a 2-to-1 scale, at least siding with the legislature previously. And so it will be interesting to see where she stands on this specific case. But I'll let Mitch speak to the federal process.
Yeah, I think ultimately constitutional law questions are very difficult to overcome, especially when there's some sort of connection, what they call that kind of rational relationship or substantial basis for making the connection between whatever action is taken by the government and whatever they say the reason for that action is. When you get into the different claims, whether it be due process or equal protection, there are different burdens, some of them higher than others. In that rational basis kind of burden, that's the lowest. It basically says, is there any kind of connection at all between what you're doing and why you're saying you're doing it? In those situations, for some of those claims, it will be difficult to overcome the governor's position. But on the due process claims, for instance, I think that the attorneys on the plaintiff's side of these federal court cases, from the complaints that I've read, they appear to put what I would say is their best foot forward. And ultimately, the court will have to decide whether this is a infringement on rights or a restriction of rights that we as a society can find as acceptable. And I think that it's a hard question for them to answer, and we have our opinions with respect to what we would like to see. Our definition of a Republican government and how the ability to operate freely and with our life, liberty, and pursuit of happiness perspective on our actions that we take. That is one that ultimately the judicial system has to try to take a step back, be more black and white than I think the position that most of us on this call would take with respect to those infringements.
So another question that came in is and we kind of tapped on this earlier, so we'll be circling back to it just a little bit. With the 4 levels of judicial oversight until we get to the state Supreme Court, won't it drag on for another 2 more months? And where is the sense of urgency? That came from Bill. So that's just normally, that's not how the judicial process works. We can't just go right to the Supreme Court. They kind of have to follow the process. I do believe the court knows that there is a sense of urgency related to this. The legislature has asked for an expedited case, and I think they're getting that. They filed last week, and oral arguments were scheduled and begin on Friday. So I know that the other court cases, they have not even had oral arguments scheduled yet. So I think it is a good sign to know that kind of within a week and a half, a little bit over a week of the initial filing of the lawsuit, that they will already be in court making their oral arguments. I think the court is going to try to move the process as fast as possible. And so that way the people of Michigan will have some kind of outcome specifically on that case. It doesn't mean that the situation is going to resolve. But like I said earlier, I do believe that this ends, this being the governor's authority, will end with a court case. I can't say it's this case, but I do believe it will end eventually with some lawsuit that is filed, whether it be this one or another one. So another question that came in is there anything that we the people can do while we are still waiting this out, and how long do you think the process will be extended beyond June 1st? And that came from Jill. I think that's a great question. I think there's a lot that people can do right now. I think people need to make their voices heard to both the governor and the legislative branches. So contacting the governor and your senator and your House member, your House of Representatives member, is really important to let them know how you feel, let them know where you stand on the issue, and letting the governor know that the people of Michigan expect a balance of power. I would argue that as we return to more of a normal sense of life, and I don't think we're going to have a normal sense of life for a while, but as the weather starts to turn and as businesses start to open up and as families start to gather again, that's a more semblance of a normal, that people are going to have the expectation that their government also begin to function in a more normal capacity. So I'm a big believer that the governor has changed direction. when really the court of public opinion is shifting against her position. And so I think it is really important for the residents of Michigan to make their position known to the governor, that they have the expectation that she work with their elected officials. It's really important to note that the House and the senators, they were elected by us to represent us and have our voices heard and be our voice in Lansing. And so just like the governor was elected by the state to represent us, letting her know that we the people believe that they are equal branches of government and that we believe that we are returning to a more normal pace. The governor has often said in her press conferences that she is going slow and she is taking her time making decisions. Well, I would argue that if she is going slow and she is taking time, then she has the time to work with our legislators to help make the decisions moving forward. It doesn't mean that it's going to be easy, but making laws is never easy. Being a legislator and executive, having to work together, our form of government was created and crafted specifically with the checks and balances of each individual branch to be difficult, to challenge each other. Even within the legislative branch, the House and the Senate are separate chambers in order to be a check and a balance on each other. And so I think making your voice known to those that were elected to serve you, that you would like everyone involved in the process, is really important. I think we have big elections coming up here in Michigan this fall. Not only are we going to be deciding, we absolutely are a swing state and we're going to be deciding the course of the presidential election here in Michigan, but we have a lot of House seats. The majority for the Michigan House of Representatives is 100% on the line. The Democrats need 4 seats to take over majority of the Michigan House. And if everybody believes that the Republican-led Senate can hold back what our Democratic governor, attorney general, secretary of state, and then add on a Democratic House to that, that should truly be terrifying for those of us who loves our freedom. We love our rights. We want to preserve the Constitution. We don't want modified election laws and socialism coming here to Michigan. So we have to really make sure that coming up this fall in all of our House elections, we are electing Republicans who want to work as hard as they can to preserve the Constitution, respect our rights. I think respecting our rights is equally as important to trying to preserve them. And so those are things that you can do, is to help ensure that Republicans in the House maintain majority, so that we have the ability to stand on the same footing with the governor and just really be involved. And I think the second part of that question was, how long is this going to last? And I wish I had a glass ball and can tell you. Hopefully not too long. So I did see there was another question that was, can the individual businesses who have been put into bankruptcy as a result of these actions, can they sue the state? The answer to that is, I am not an attorney and I know there are reasons that individuals can sue. However, I am a very adamant believer that there have been a number of individuals from businesses that have declared bankruptcy to individuals who have passed away because they have not been able to get elective medical treatment. I actually personally know individuals who passed away because they had delayed treatments dealing with colonoscopies and other health issues, and they were not able to wait out the 2 months. And so if you have a health issue, if you were a business that was harmed, if you were an individual that's been directly harmed, I believe that they probably have some basis for a lawsuit and they should probably seek counsel. Mitch, do you want to add anything to that?
I think you should certainly seek counsel. I think that it's real difficult for us to answer a very fact specific question here. There's a lot of folks, as you can see and as Megan said, that are pulling the trigger on lawsuits, but it's whether you have standing, whether the issue has not already been decided, what's your decision, what's your motivation for the lawsuit, whether it's just, again, to get your voice out there, whether you're seeking some sort of damages. Those are all very fact-specific questions that I think you should certainly review with your attorney. I guess the lawyer answer is it depends, and you have to evaluate each factual situation for what the facts are.
So we did have another question come in that was related to a recall petition. I have heard the rumblings of people trying to do a recall. I know that the State Board of Canvassers met about a week ago to have an initial hearing on a petition for recall. That recall was withdrawn from the Board of Canvassers and may have to go forward. The state has some pretty strong rules, and it's very challenging to recall an elected official, especially one at the level of the governor. The number of signatures that are required is a really big hurdle. You have to collect those, I believe, within 120 days once the recall is approved by the State Board of Canvassers. So I have heard of different organizations who are currently working on recall petition and possibly looking to submit that to the Board of Canvassers, which they are the body that approves all of those type of ballot initiatives that go on the ballot for us and the public to vote on. Can the president, so this came in from Taryn, can the president rescind the order of Governor Whitmer being able to use the National Guard, or does that have to go through a court? Mitch, do you have an answer on that? I think that's a great question.
It is a good question. I don't have the specific answer. It's certainly something we can find out and get back with you, Taryn, perhaps post in the comments. Typically, the governor has control over the National Guard. And there are certain reasons for why that is the case. But we can take it offline and look into that just to get you an answer.
And it might depend on the specific language in the wording, whether or not the president has any authorization to end that order faster than what was originally granted. So Jeanette asked, based off of the governor's words stating that the executive order is law, to her understanding, an executive order is not law, but more of a recommendation. Can you please explain that? So under the emergency management, the original, Mitch, and you can correct me if you think I'm wrong here, but the original intent was that the executive order itself bears the weight of law. Now, here's where I think some disagreements come in, is the governor's original executive orders, and I mean a number of them, the original stay-at-home order and even the new ones, they have all been supplemented with a frequently asked questions section that the governor is using to, quote, clarify her executive orders. From my understanding and from what I personally believe is that the initial executive orders carry the weight of law. However, she cannot use the frequently asked questions section to modify the order, add anything to the order, subtract anything to the order, and the frequently asked question portions do not carry the same weight of law as the original language issued in the executive order. I think where the disagreement comes in is recently after the legislature denied her extension at the end of last month. Now we get into a question of what type of weight do those executive orders, the new ones that she has issued, what type of weight do they carry? The governor firmly believes that she has this authority to every 28 days issue a new state of emergency, and she believes that those orders definitely carry the weight of law. There are others out there like myself and obviously the legislature that have, since they have filed a lawsuit, that believe the orders issued after the denial of the extension do not carry the same weight as law. And so I think that's where the disagreement is coming in. I would also like to point out that these executive orders that the governor issues throughout when a state of emergency is declared, they are unique. So our Constitution and our laws allow the legislature to overturn governor's executive orders during normal time. So if the governor issues an executive order, our legislature can normally meet, and with a vote, they can override that executive order. Those are things related to, there are certain things that the governor has the ability to do through executive orders, such as restructuring state departments. And however, under the executive, under the powers vested in the governor through the emergency management laws, those executive orders are not they cannot do an override on any of those executive orders. So our legislature has no oversight and no veto powers over the executive orders that the governor issues during a state of emergency. They are not like the normal state executive orders that the governor issues during normal times. Just to point that out, there is a difference there. Mitch, do you have anything to add?
No, you covered it. I think just the recap being that there is the question of how far the order goes with respect to the FAQ or not. I think my personal opinion is also that the FAQ create issues for the governor with respect to the enforceability of what's in the FAQ. And then also, as you recall from the discussion of the 2 federal court cases, the void for vagueness standard, the fact that there are FAQs shows that these orders are in fact vague and should be voided. And then with respect to the treatment of this Emergency Management Act and the ability to overturn executive orders, yeah, you're exactly right. That as written, the law allows the governor to have the final say, and now the question becomes how long does that last, and that's what's being evaluated in the courts.
So Marcia sent in a question asking if the governor can extend the stay-at-home order past June. And that is a great question. And I think that is a question that eventually the courts are going to decide through the legislative lawsuit as to when the governor or how long the governor can potentially issue. And I don't know that they're going to give a timeline. They might be able to. On when the governor's authority to issue a stay-at-home order is going to end. I personally believe that on May 28th, when the current order is set to expire, I do not see the governor just lifting the stay-at-home order and allowing all recreational travel and other things. I just see that there is, she has a lot of indicators that show she is interested in keeping the state kind of locked down as long as possible. Under the 6-step plan that she released, she says that we are only in phase 3. She has not released the criteria, the data criteria to move to the second phases, but there have been a lot of independent analysis done that say that our state or a large number of our states should be in phase 4. Even the mayor of Detroit said during a media conference earlier today that he believes the city of Detroit will be ready to enter phase 4 in, quote, the next couple of weeks. So if the city, which is kind of where the hot spot of Michigan is ready to enter phase 4 in the next couple of weeks, that means that areas of our state like up north and the lower northern Michigan are probably ready to enter late phase 4 or even phase 5. So yes, she can extend the order past June. The way that the emergency management laws work, and I'm talking about how they're written now and how the governor is enforcing them. I'm not talking about if there's any court intervention in these, is that during the time that the governor has authority, so currently she has authority until May 28th, she can issue an order that lasts, let's say, 10 days, 30 days, 45 days, 120 days. However, once the emergency declaration ends, so if she declares the stay-at-home order, let's say until the end of August, but at the end of July, the state of emergency ends, all of those executive authorities that she issued will end at that same time. So even if she makes the order last longer, they will end when that emergency declaration ends if it goes longer. One of the other questions that we received is if the legislature wins their case and the emergency orders or the executive orders are thrown out, has the governor's unwillingness to work with the legislature put Michigan in a worse position? Also, would the legislature politically be able to work with the governor on restrictions? So I have worked in the legislative branch for close to 20 years. And the reason I have done so is I love listening to the concerns of the residents that I represent, working with them to find solutions, and then being a part of the process that creates the laws of which we and my children and the next generation have to live under, and making sure that those don't infringe on my freedoms and my rights, and they do what they can to help the public. So I believe that it is imperative that everybody who's elected to the legislative branch and the executive branch, you don't have to agree on every issue, but you need to find a way to work together for the benefit of those that you represent. And I don't agree with Democrats on a lot of issues, but the bottom line is, for the best thing of the residents that we represent, it is not good for two things. One, it is not good for the governor to act as a unilateral authority to issue executive orders and run the state herself. That is not the representative republic that is prescribed underneath our Constitution. It's not going to help us protect our rights. It is not going to help protect individual freedoms, everything that's important to us. And our government, whether on the federal level or the state level, was never created with the intent to have one person be basically a dictator and run everything. So it's not healthy from that perspective. Secondly, it's just not helpful to the people that we represent. The residents of Michigan and the residents of Livingston County really want elected leaders that can get something accomplished. And if the legislature and the governor, when we get done with this, end up just throwing stones at each other, that is not going to be helpful to the residents of our state, who are really left picking up an economic disaster once we're done. That's something that the governor has today during her press conference addressed a little bit, but you can clearly tell that the governor is pending and hanging her hopes and dreams on getting a bailout from the federal government to help the over $3 billion budget deficit that we are facing in the remaining 4.5 months of this fiscal year. And there's a lot of contention up on Capitol Hill in DC related to whether or not they are going to send the states federal bailout money. And if I were to hedge my bet right now, I don't think they're going to. And if they do, it won't be everything that we have to cut. So the families of Michigan, the residents of Livingston County, they are going to be faced with an economic disaster. They can't collect unemployment. It's taking them weeks to do so. They don't have jobs. There's 25% of businesses are confident that they're going to make it through this. The rest are doubtful. And I've already heard from dozens of business owners who have decided to close their business because they are not going to make it through COVID. All of those small businesses are the backbone to our state. And without them, there are going to be families that don't have a job to go back to. So I think it's in the best interest of everyone for them to find a way past this to get along so that we can help rebuild our economy, help our families stabilize, continue to educate our kids, and really get our state not go back to another lost decade, and really move forward on the progress that we've made over the past 8 years.
Megan, I couldn't have said it better myself. I think I just want to add, I have a lot of confidence in our local legislatures, and I know that Megan, when successful as we go through this campaign season, I know she will continue the great work that's been done, and certainly will, I think, ramp it up quite a bit. There's always questions of what is my legislature, or what is my representative, what is my senator doing for me. I think what many of you can see by the work that Megan's doing so far in her career, but then also all the information she's been providing. And again, I'm happy to be a part of working on providing you guys all this information. But seeing what she's able to do, I think, is just a small glimmer of what she'll do for us here in our county going forward. So thanks,
So
Megan.
thank you. We had another question come in. Mitch, I'll punt this one over to you, and then I'll take the next one. How does the state of emergency end?
So procedurally, I suppose, from the perspective of when the time runs out on the order itself, it is strictly based on the time, or if the courts intervene and say that it's gone on long enough as a result of any of these lawsuits, particularly at the state level. There will have to be a second step if any of the federal lawsuits get teeth, much like the first lawsuit we looked at today when we were talking about how the the elections couldn't be directly dictated by the federal court, they would issue a level of an order, a proclamation type of declaration that would say the state has to do ABC to fix this issue, and then the state would have to act to get it fixed. So it could be things run out of time, the governor changes her ways, we no longer see these extensions upon extensions, or perhaps they become more limited in nature. To go back on a couple of the other questions with respect to the presenting different regions within the state. If we compare Wayne County and Oakland County, they have over a third of, almost probably half of all the cases in the state at this point. Those should perhaps be treated differently than a Livingston County, an Ingham County, a Shiawassee, and as we go west and north, we know that the issue subsides significantly compared to Southeast Michigan. So matter of time, a matter of operation of the court, I guess, is the short answer.
So the next question came in, and that is, when will the governor start laying off state employees? And when will we be hit with tax increases to cover the budget shortfall? So that's a great question, and one that I could give a really long answer to. The governor has already furloughed state employees for a number of days, but what the governor did is she furloughed the state employees and she put them on the unemployment assistance that is coming through from the federal government. I know that last Friday, I'm going to take one quick detour on the budget question to address unemployment really quick, which is a disastrously broken system that I have heard from hundreds of residents with their frustrations that they have not been able to file or even get through to the system weeks later. Even once their claims have been certified, they're still not getting their money. And so I think that's an issue that the legislature really needs to work to address as quickly as possible, and helping try to fix that system for the residents. Last Friday, as the governor extended the stay-at-home order another 2 weeks, one of the questions that was asked of her is, because she is extending the stay-at-home order, how long is the unemployment benefits that the federal government gave to the state going to last? And her answer to that was, I don't know. They kind of asked again and said, you don't have a date of when those benefits are going to run out or expire. And her response was, no, I don't have a date on me. I talk to the unemployment director frequently, and I guess I can ask for a date if you would like me to, and follow back up with you. I have seen some studies and some news articles. I have been doing some research related to the unemployment fund, and I know that it took 9 years to build up the balance of the state unemployment fund, and they expect that to be gone, I believe it was within 9 months, if our unemployment claims continue how they have been. So that is a concern. So to specifically answer your question, for state employees were already furloughed, and I don't care what type of tax increases, if the legislature were to consider or the governor were to propose, you cannot tax your way out of the budget creator in the economic nightmare that is coming down the pipeline at our state. Keeping the health of the public is important, but I think when the families of Michigan realize the economic calamities that is as a result of the COVID crisis, we are going to be facing a second crisis. And you can't squeeze blood out of a turnip. You can't consider tax increases. There is no money left in businesses. Small business owners have not only gone through their business savings, they're now going through their personal savings just to try to save their businesses. There's nothing there to tax. Large corporations have been doing everything they can at cost to build face masks and ventilators. There's not much there to tax. Families of Michigan are now collecting unemployment, and after they're going to lose their job, there's not more there to tax. The state is going to have to look at some very painful, very real budget cuts. I'm a fiscal conservative. I believe the state does spend too much money, but cutting that much of the budget that fast, there is no doubt it is going to be painful, and it is probably going to have some economic impact on us as a state, and it will affect everyone. I would hope that they don't look at tax increases. The residents couldn't pay for a 40+ cent gas tax. They surely cannot pay more on income taxes or sales taxes at this time. So I think with that, if there is one last question, we're open to taking that. If not, I know we have been on for close to an hour and a half. I just wanted to tell everybody thank you for tuning in tonight. I appreciate it so much. I really want to listen to your concerns. I want to be available as a candidate running to be your next state representative here in Livingston County, to listen, be open, provide information, and kind of show you what type of state representative I would be if you were to elect me. Please feel free to call me on my cell phone, that number, and I will post it in a post here when we're done, is 810-522-8265. Feel free to give me a call. Let me know your thoughts. Ask me opinions, or ask for my thoughts. Ask me where I stand on the issues. Get to know me a little bit better. You can also visit my website at www.meganreckling.com, and you can send me an email at megan@meganreckling.com. So I really appreciate everybody tuning in tonight. I hope to earn your vote on August 4th, and I continue to show you what kind of representative I would be. And I'm going to kick it over to Mitch.
Sure. Thanks, Megan. And I likewise appreciate everyone's attention. The great questions, great thoughts. I think that we make progress when we all collaborate together. This is one aspect of my One Livingston plan, hashtag One Livingston. The goal is to always be open and have a line of communication, not only to peers, whether it be on the commission, at the state director level, into Lansing, working with Megan, as I know we will certainly work closely after November and into January as we get these campaigns wrapped up and get down to work. But our goal is to always remain open to you, open to our colleagues at our various levels, and work to implement those types of questions, comments, inputs into our strategies as conservatives and Republicans in Livingston County to work always to the betterment of our constituents. I will also post my information. It's real easy. Mitch@mitchellzajac.com is my email. My website, mitchellzajac.com with 2 L's. And then also my cell phone number is 517-285-8226. I'll post that as well. Always will remain open. Look very much forward to doing these types of events again, keeping the lines of communications open and working for a better One Livingston into the future.
So thank you everybody for tuning in tonight. We greatly appreciate it. Hope you learned something about the lawsuits and the process. And if you still have outstanding questions, you have our contact information. We look forward to next time that we can join you. Thanks everyone. Stay safe and have a great night. God bless America.